Hello, everyone. Thank you for joining us today for our second day of the Denton's Ontario Labour and Employment Spring Seminar Webinar Series for 2022. My name is Matthew Curtis. I'm a partner in the Labour and Employment Group here in Toronto, and I'm pleased to be joined today by my colleagues, Emily Kroboth, an associate in our Toronto office and also a labour and employment lawyer, as well as Karina Pepilchek, a senior associate in our Toronto office with a specialization on labor and employment. Today, Emily will start us off with a discussion about what you need to know about the new mandatory disconnect from work policy in Ontario. After Emily, I will be presenting on non-competition agreements and the new Ontario legislation pertaining to non-competes. And finally, Karina will be speaking about working with the WSIB, the Workplace Safety and Insurance Board.
Thanks so much, Matt. And hello, everyone. Thanks so much for joining us today. So as Matt mentioned, I'll just be going over some information that you need to know regarding the new disconnecting from work policy in Ontario. So as I'm sure many of you know, on October 25th, 2021, the Ontario government passed Bill 27, the Working for Workers Act. And this bill contained an amendment to the Employment Standards Act requiring employers to implement a policy with respect to disconnecting from work by June 2nd, 2022. Currently, Ontario is the only province in Canada with this requirement. And in today's seminar, we'll set out exactly what that means for employers within Ontario-based employees. So just moving to the next slide. The Employment Standards Act defines disconnecting from work as not engaging in work-related communications, including emails, telephone calls, video calls, or the sending or reviewing of other messages, so as to be free from the performance of work. The legal requirement for a policy with respect to disconnecting from work is simply to have one. Currently, there are no specific requirements for the content of these policies. The Employment Standards Act states that the policy must contain information as may be prescribed, but at the moment there are no regulations that explain exactly what this prescribed information is. So currently in Ontario, there isn't really so much a right to disconnect, but there is a requirement for workplaces with 25 or more employees to have a policy that addresses disconnecting from work and what that means at your particular organization. The Ontario government's guide to the Employment Standards Act also explicitly states, the ESA does not require an employer to create a new right for employees to disconnect from work and be free from the obligation to engage in work-related communications in its policies. Employee rights under the ESA to not perform work are established through other ESA rules like hours of work or overtime rules. Ultimately, despite what we're seeing in the news or on social media over the past few months, there is not yet a right to disconnect, and there is no legal requirement that you not contact employees outside of working hours. It is the employer who decides upon the actual contents of this policy. However, note that that may change if and when the government releases any regulations addressing this. So just moving to the next slide. To go over some basics of this policy. So who needs this policy? Employers with 25 or more Ontario employees across all locations as of January 1st, 2022 require this policy. When do employers need this policy by? June 2nd, 2022. Do employers need to receive a copy of this policy? Yes, employees must receive a copy of the policy within 30 days of its introduction at your workplace, and they must also receive any updates to the policy within 30 days. The date of the original policy, as well as the date of any changes to the policy, must also be reflected on the policy itself. Can employers have multiple policies for different employees? Yes, every employee must be covered by a disconnecting from work policy, but it does not have to be the same policy. So if you have some employees performing shift work and other employees performing more of a 9 to 5, You can separate out those groups of people and have them covered by two different policies, so long as everyone has the coverage of a disconnecting from work policy. Do employers need to retain a copy of the disconnecting from work policy? Yes, employers must retain a copy of this policy for 3 years after the policy is no longer in effect. Jumping to the next slide. So we've established that there are currently no explicit requirements regarding the contents of a disconnecting from work policy. But that being said, practically speaking, what should your policy say? A lot depends on your particular organization. Are there some limits or boundaries you can comfortably set and follow? It might be a good idea to start thinking about non-traditional working hours, for example. Does your organization employ parents who are dividing their days differently, maybe working very early in the morning or very late at night to accommodate childcare? Further, many organizations are global. Do you need to consider when multiple time zones need to be accommodated across your organization? Another thing to think about is encouraging managers and leadership to send communications during regular working hours. Your policy could assist in creating a culture of communication, mainly during work hours, if that's something that works for your organization. A final thing to consider is disconnecting from work as a retention strategy. We are currently in the midst of what some are calling the Great Resignation. So it could be worth thinking about how a disconnecting from work policy could be a part of your overall retention strategy. If you're receiving feedback from exit interviews that touch on burnout, especially over the past 2 years with the pandemic, which we've seen a lot, this policy could be a tool to benefit both employee well-being and overall retention. However, as a caveat to this, the Ontario Guide to the Employment Standards Act states that if employers give employees the right not to perform work, this may amount to a greater right or benefit and be enforceable under the ESA. This is important to keep in mind if you would like to use this as a retention strategy, as it may create additional and potentially legally enforceable obligations. However, if your policy on disconnecting from work does not create a greater right or benefit, then the policy will not be enforceable under the ESA. So moving to the next slide. So just a few key takeaways regarding the right to disconnect in Ontario. Firstly, employers require a disconnecting from work policy by June 2nd, 2022. Further clarity on what the right to disconnect is and what that means may come if and when the Ontario government decides to release regulations. Although there is no right to disconnect, a disconnecting from work policy may help with employee burnout and retention. And ultimately, we won't have any further clarity on what exactly the right to disconnect is until any regulations are released. As Matt mentioned earlier, the Toronto Labour and Employment Group has prepared a draft disconnecting from work policy, along with a frequently asked questions document that you may choose to use for your organization to meet that June 2nd deadline. Now I'd like to pass it off to back to my colleague, Matthew, who will provide you with an update on non-competition agreements.
Great, thank you, Emily. So my topic today is on non-competition covenants and new legislation that pertains to employees in Ontario with respect to non-compete agreements. So moving on to the next slide. Last year, on November 30th, 2021, the Ontario government passed new legislation called the Working for Workers Act. It was Bill 27, and it has a limited ban on post-employment non-competition agreements. These are agreements that prohibit an employee for a set period of time from working for a competitor, for a competitive business. Under the legislation, employers in Ontario are prohibited from entering into non-compete agreements with their employees, but there are some exceptions, and we'll talk about the exception shortly. It's important, though, to note that this ban on non-competes only applies to non-competition agreements that apply after the employment relationship has ended. That means if you have a prohibition with an employee that they can't work for a competitor while they're employed, that's unaffected by the legislation. It only has to do with restrictions on their ability to either resign and work for a competitor, or if their employment's terminated by the company, to go work for a competitor afterwards. So that's an important qualification with respect to this new legislation. And the new legislation is now in effect. The other point is that the Ontario Ministry of Labour's position is that it only applies to non-competition agreements or covenants that are entered into after October 25th, 2021. That means if you have an existing employment agreement with a non-compete that was entered into prior to October 25th, 2021, it does not get affected by this new legislation. That being said, the courts, the civil courts, still have the jurisdiction to assess whether a non-competition agreement is enforceable or not under the common law, and whether it's reasonable. Generally speaking, courts in Ontario dislike non-compete agreements because they're viewed as being a restraint on trade. Now, that doesn't mean you can't have them, but it does mean that there's very close and careful scrutiny by the courts when it comes to whether they're enforceable or not. And that's typically challenged in injunctive relief that is sought in cases where an employee goes to work elsewhere in breach of a non-compete agreement. The changes under the legislation now allow the Ministry of Labour to state that a non-compete agreement violates the Ontario Employment Standards Act if the non-compete is entered into after October 25th, 2021, and if there are no exceptions that apply to the non-compete. So speaking of exceptions, we'll move to the next slide. So the application, again, of the ban is it applies only to employees working in Ontario and who are subject to the Ontario Employment Standards Act. That means if you're a company or an organization that's headquartered in Ontario, but has employees who are working in Alberta or British Columbia or Quebec, those employees will not be covered under the Employment Standards Act of Ontario. And as such, this new ban on post-employment non-competition agreements will not apply to those employees working outside of Ontario, unless those employees working outside of Ontario is viewed as being a continuation of work that they did in Ontario. The ban also only applies between an employer and an employee. But one thing to note, and we get this question a lot with respect to, does it only apply to employment agreements? The answer is no, it applies broader than an employment agreement. The legislation says it includes an agreement or any part of an agreement between an employer and an employee. So just because the non-compete agreement may exist outside of an employment agreement doesn't mean it won't attract the scrutiny of this legislation and potentially the Ministry of Labour. Now, I did mention the exceptions. There's three main exceptions. First exception is the non-compete agreement in question needs to have been entered after October 25th, 2021. But then there's also the sale of business exception. And that's one where, as part of a sale of a business or a lease of a business, the seller or the lessor becomes an employee of the purchaser as part of the sale or the lease. And if that employee becomes of the seller becomes employed by the purchaser, the limited ban on non-competition covenants will not apply as part of the Ontario Employment Standards Act. There's an explicit exception there. The third exception is where the employee is an executive. And there's actually a definition of what constitutes an executive for the purposes of this exception. And I've reprinted it here. that it's anyone who holds the office of a CEO, president, chief administrative officer, chief operating officer, chief financial officer, chief information officer, chief legal officer, chief human resources officer, or chief corporate development officer. Those positions are exempt from the ban. It also says anyone who holds any other chief executive position. I'm expecting that there will be reported decisions on that last provision because it's a bit less clear. But I would argue that anyone who holds the position with the title chief and is at or is in an executive capacity in an organizational chart, and they're at the top of their respective part of the organizational chart, they may constitute holding a chief executive position. It does not just apply to the CEO or the president of an organization, but it also likely will not involve or include a junior manager or supervisor. So we'll move on to the next slide. There's only one case that's been reported as of today's date with respect to the new legislation and how it's been scrutinized by the courts in Ontario. That's because the legislation is fairly new, and it will take some time before it gets interpreted both at the Ontario Labour Relations Board and also in the Superior Court of Ontario. So in this case, Prakash and Schechter, it's a 2022 case of the Ontario Superior Court. And in this case, the dental corporation sought an injunction against a former employee in order to prevent him from practicing dentistry at another business. There had been a sale of a business, and the employee had signed on to a non-competition covenant restricting employment anywhere within a 5-kilometer radius of the dental practice for a period of 2 years after employment had ended with the dental practice. But less than 2 years after the sale, the employee resigned from his employment and began working at a competing dental corporation. There was an issue about whether it was 5 kilometers or not. Apparently the drive was more than 5 kilometers, but the radius was within the 5-kilometer radius of the plaintiff's dental practice. One of the arguments that the former employee made was that this new ban on non-competition covenants would render the non-compete, in this case, void and unenforceable. But the court found that there was clear and express legislative intent to make the amendments to the Ontario Employment Standards Act applicable as of October 25th, 2021, and not earlier. So the court was not going to apply the non-compete ban any earlier than October 25th, 2021, and that's in keeping with the Ontario Ministry of Labour's position as well. And as such, the ban on non-competition agreements introduced by the ESA did not apply in this case. Furthermore, arguably the sale of business provision and exception would apply as well. So we'll move on to the next slide. And with that, we'll move on to my colleague, Karina Papilchek, who will be speaking on working with the WSIB.
Thank you, Matthew, and hello to everyone. So I am going to be speaking, like Matt said, on working with the WSIB. So our first slide just sets out an agenda. So I'm going to talk about the WSIB claim process, then we'll talk about WSIB reemployment obligations, and finally about WSIB appeals. So turning first to the WSIB claim process. So claims are typically initiated by a worker filing their Form 6. They have to file that within 6 months of the date of the accident or injury. However, the WSIB does have the discretion to extend that timeline. They do tend to take a fairly firm approach if it's just a matter of, the worker chose not to report, They were aware of it, they sought medical attention and didn't report it in time. However, if there's circumstances where, say, for example, the WSIB finds that an employer didn't make the worker aware of their right to file a claim, or even went so far as to kind of try and dissuade them from doing so, that, for example, would be a circumstance in which the WSIB will extend that 6-month timeline. So once the employee files their Form 6, the employer then has an obligation to file their Form 7. And an employer is obligated to report a work-related accident in the event that the employee required health care and/or was absent from regular work, earned less than their regular pay for regular work, required modified duties at less than regular pay, or required modified duties at regular pay for more than 7 calendar days. So as you can see, there's a few different circumstances in which you would be required to report on a workplace accident. The employer's deadline is, if we can just go back to the previous slide. The employer's deadline is 7 business days from becoming aware of the reporting obligation. So in a situation where the worker reports their accident to you, it's obvious when your reporting obligation has started. There are often circumstances where the employer isn't necessarily aware that the workplace accident has occurred, usually because the worker hasn't reported it to their supervisor or manager. So in that case, what will typically happen is the worker will file their Form 6. The WSIB will then write to the employer to say, we have received a Form 6, we haven't received your Form 7, where is it? Just be aware that oftentimes those letters will contain a warning to the employer in terms of, one, what your obligation was in terms of filing a Form 7, but also that the WSIB has the ability to award penalties and fines for not filing a Form 7 on time. The best course of action in that situation, pick up the phone, call the case manager who's listed on that letter, inform them that you weren't aware of the workplace accident or injury, and that you are going to file your Form 7, and make sure that it's done, as soon as possible, if, no more than within 7 days. Okay, next slide. So once a claim has been initiated and is with the WSIB, they then go through their process of determining eligibility for WSIB benefits. There's a couple of different issues that they will look at. The first being, whether it is work-related. So did it occur in the course of employment? The most obvious is when it occurs in your actual workplace, but there can be situations as well where employees are traveling to and from work events, traveling for deliveries, things like that. Generally, traveling for work purposes will be covered, but traveling to and from your home and to work, that would not be covered. Pre-existing conditions are an issue that comes up a lot in addressing initial entitlement. So for example, a worker has a slip and fall at work, injures their back, but there is evidence that there is a pre-existing disc degeneration or a hernia or something like that that has caused a pre-existing back condition. And so what the WSIB does in those circumstances is they first look at that initial entitlement. So do we think that, or do we find that there has been a workplace accident and that there was an injury as a result? And then they will look at what impact that pre-existing condition has on the employee's health. So if it has no impact on their impairment, then it has no impact on their entitlement to benefits. Benefits continue in the normal course. If they find that the pre-existing condition is impacting the employee's impairment, the benefits will continue so long as the work-related illness or injury continues to significantly contribute to the worker's impairment. So it's at that point that the pre-existing condition takes over, causing or significant contribution to the worker's impairment that the WSIB would then assess should the loss of earning benefits end. Next slide, please. So in that claims determination process, there will typically be contact between the WSIB case manager and the parties involved, so the worker and the employer. The most important thing for employers to remember in this process is timely communication with the WSIB. So one of the principles of the WSIB is that they want to return workers to safe work as soon as possible. And so they are quite proactive in their communications and their efforts to resolve claims. So one of the things that we often suggest is to have one key person who is the contact point on a WSIB file, so that you don't have situations where, one person spoke to the WSIB this week, the WSIB is trying to get in contact with them again, but really it should be going to a different person. You want to avoid that type of confusion. If you are going to assign one person, just be mindful that if that person is going to go on an extended vacation or leave, to assign someone else and make the WSIB aware of that so that they don't have situations where they're trying for weeks on end to contact the employer and can't get a response. Depending on the nature of the claim, the level of communication with the case manager will differ. So sometimes it's quite limited. In claims where there is perhaps an allegation of workplace harassment, that of course is going to involve more communication because the case manager will want to get factual details from the employer. And then just in terms of sharing information with the WSIB, I just say to be mindful that the WSIB keeps written records of every conversation that a case manager has with the employer. So obviously you want to share information that assists in making the claims determination, but just be mindful that all of those conversations are recorded in the claim file. Next slide, please. So on the issue of return to work, Section 40 sub 1 of the Workplace Safety and Insurance Act requires that employers cooperate with the return to work process. There is also an obligation on the worker to cooperate with that process. In terms of when that return to work process should start, my recommendation is that employers actively engage with the employee and the WSIB in determining when the employee can return to work as soon as possible. So it's not necessary to wait for the WSIB to tell you that the employee can return to work. You can contact the employee directly and offer modified duties. There may be a situation where the employee says, based on the recommendations from my health provider at this time, I don't think I can perform those modified duties, or I'm not able to return to work at all. That's okay, that will get dealt with and determined. But the sooner the employer offers modified work, if the WSIB ultimately finds that that modified work was suitable and should have been accepted by the worker, that can minimize or diminish the amount of lost time and loss of earnings benefits that are paid. That's significant because generally the more lost time and the more loss of earning benefits paid, the higher your premiums become, because premiums are in part determined by the number of claims and the cost of those claims. So when you're looking at that modified work and returning the employee to work, you will obviously look at whether they can perform their own position with or without modifications, but also consider whether you have different positions that could be offered. So a lot of times we will see where there's been a physical accident or injury, the offer of more administrative type duties if the employee is capable and qualified to perform those. In the event that the employee's capabilities or the required modifications aren't entirely clear, or there's just a dispute about that, the WSIB will assign a return to work specialist, and that specialist will meet with the worker and the employer to help assess what modifications should be provided and if there is suitable modified work available. And then just finally, as you go through that claim process and trying to return a worker to work, you will receive WSIB functional abilities forms that are completed by the worker's physician that help provide that information in terms of what are the restrictions and abilities. Okay, so now we're going to talk about WSIB reemployment obligations. So this comes up in the context of having an employee who is on a approved WSIB claim. They are not at work, they're receiving loss of earnings payments, and they aren't able to return to work in a short duration. So the question then comes up as to, how long does the employer have to hold their position open for, or hold employment in general? Section 41 of the Workplace Safety and Insurance Act imposes an obligation to reemploy on employers. So there's a prerequisite, which is that the worker has to have been employed by the employer for at least 1 year prior to the date of the injury. Once that prerequisite is met, the obligation to reemploy applies. And that obligation lasts until the earlier of 2 years from the date of the injury, 1 year after the employee is medically able to perform their pre-injury duties, and the employee reaching age 65. So when you do have an employee who the determination is made that they are able to perform their pre-injury duties, the employer then has an obligation to offer them either their pre-injury position, if that still exists, and if it doesn't, a position that's nature and earnings are comparable to the employee's pre-injury position. So the WSIB is not just a matter of saying, your position doesn't exist, but we have one that pays the same salary. They also look at the nature of the position. So similar duties performed. One of the things they'll also look at is location. So you don't necessarily have to have a position available at, the same warehouse or the same office, but bearing in mind that if you then offer the employee something that takes them a 5-hour drive away or requires them moving, that is, obviously not going to be considered comparable. Next slide, please. So assuming that you do return the worker to work, either in their pre-injury position or in something comparable, if you return them and then subsequently they are terminated within 6 months of returning to work, the WSIB automatically applies a presumption that the employer has breached their WSIB reemployment obligations. So essentially, the WSIB presumes that you have terminated the worker because of their WSIB injury. The WSIB does then give the employer an opportunity to rebut that assumption. And so the employer has to show that the decision to terminate was entirely unrelated to the WSIB claim. So it's not sufficient to say, yes, the WSIB claim, and the injury played part of it, but also there were performance issues or attendance issues or things like that. It has to be proven that the decision was entirely unrelated to the WSIB claim and injury. If the WSIB finds that the employer has breached that reemployment obligation, financial penalties follow, and those are typically in the form of the WSIB awarding reemployment payments to the worker, which essentially mimic loss of earning benefits. So it's that same full LOE calculation, and then the employer is required to pay that to the WSIB. Okay, so now we're just going to talk briefly about WSIB appeals and how that process works. So once the WSIB receives a claim, they will go through their initial eligibility and entitlement assessment, and then they will issue a written decision to both the worker and the employer. Immediately after that decision is issued, either party, so the worker or the employer, can write to the WSIB to provide additional or new information that wasn't considered at the time the decision was made, and request that the WSIB reconsider that decision. The reconsideration is conducted by the same case manager that issued that initial decision. So they will then issue a subsequent letter that says, based on the additional information provided by the worker or the employer, I have reconsidered my decision, and I have either upheld the existing decision or I have changed it in some way or the other. Reconsideration is not a required step, so the parties don't have to go through that process before proceeding with an appeal, but it is an option that is there, and it typically, results in a fairly fast or expeditious outcome. After the reconsideration process, the next would be the intent to object process. So for return to work or reemployment obligation decisions, the deadline to object is 30 days. For all other decisions, so entitlement, loss of earnings calculations, non-economic loss awards calculations, those are all on a 6-month appeal timeline. And what happens in that situation is you will file an intent to object form. Once that is filed, the WSIB will contact the other party to advise them that an intent to object has been filed, and give them the opportunity to file a participant form so that you continue to stay involved in and aware of that appeal process. Next slide, please. So I went ahead and touched on some of this already, but like I said, the WSIB will provide an employer participant form that must be filed within 30 days of receiving that, or sorry, the WSIB issuing that letter. It also gives an opportunity to request that the hearing of the intent to object be conducted either in writing or through an oral hearing. If working with external legal counsel, this would also be a great opportunity to then file your direction of authorization form, which gives your external counsel the ability to, one, communicate with the WSIB directly, whether through phone or in writing, but also ensures that they receive all communications from the WSIB. And until that direction of authorization is filed, the WSIB will not let us be involved at all. So if I call the WSIB to speak to them about your claim and that direction of authorization is not on file, they will not tell me anything. The next steps are then receipt of the claim file. So the WSIB does give the worker an opportunity to object to the employer receiving that claim file. In my experience, it doesn't happen very often. And the WSIB does make the worker aware that if they object, it may impede the ability of the parties to proceed with the appeal. Once you receive that claim file, it's obviously important to review the claim file for the content of it, what impact those documents have on the appeal. It will contain the worker's medical records, communications with the WSIB. Like I said, all of those phone calls are recorded in the claim file. But at that point, it's also important to consider whether there's any missing information. So sometimes employers will have documents about the return to work process, offers of modified work, details about the accident. If those documents aren't in the claim file, then it's important to submit those to the WSIB so that they can be added. And then a very interesting fact about the WSIB that surprises many is that the hearing will not proceed until the objecting party files their appeal readiness form, and there is no deadline to do that. So a WSIB appeal can sit for months and even years before before the objecting party says that they want to proceed to a hearing, which is why it's really important in WSIB files to paper your record, keep your notes, things like that, because memories obviously fade over time. And there are definitely situations where you could be going to a hearing 2-3 years after the workplace accident occurred. Next slide, please. So in addition to, papering your file and making sure that you have everything added to the WSIB record that isn't there, it's important to note that everything in the WSIB claim file goes into evidence at the hearing and does not have to be independently proven. So if you've ever participated in or been a part of a arbitration, a human rights hearing, a civil proceeding, you'll know that documents have to be proven. That doesn't happen in the WSIB appeal process. Everything that's in the claim file goes in. So that can sometimes make it easier in terms of proving your claim or disputing the claim, but obviously sometimes it can make it a little bit more difficult because the ability to challenge certain facts isn't as easy. So as I mentioned, the appeals can be decided either by way of written submissions or through an oral hearing. The WSIB ultimately makes that decision. Like I said, the parties will be given an opportunity to request one or the other, and then the WSIB makes their decision. As of right now, oral hearings are still being conducted virtually, so either through a video conference on Zoom or through a telephone conference. The WSIB appeal process is less formal than a civil proceeding or being in court. And it's less adversarial in the sense that the WSIB really approaches it from a concept of fact-finding as opposed to, being in opposed adversarial position. So one of the areas where we note that specifically is that the WSIB refers to it as cross-questioning as opposed to cross-examining. So when your counsel is, questioning either the worker or a different witness, it is, important to ensure that it's not adversarial and it's more about getting to those key facts. Who can ask questions of a witness? So again, in that less formal context, you will very often see the appeals resolution officer, who is the adjudicator of the appeal, step in the middle of direct questioning, cross-questioning, or after the questioning to ask their own questions about facts that may still be concerning for them. And then finally, the last slide is just on appeals to the Workplace Safety and Insurance Tribunal. So that is the final level of appeal. So once a WSIB decision has been made final, it's gone through that appeals resolution officer intent to object process. The only level of appeal beyond that is to the Workplace Safety and Insurance Tribunal, or the WSIAT. There is a 6-month deadline to file a notice of appeal. However, unlike the WSIB, there is a time limit for getting it to a hearing. So once you file that notice of appeal form, a second confirmation of appeal form must be submitted within 24 months. If it's not filed, it's still up to the WSIAT to decide whether or not they want to close the appeal or allow it to continue. So they do have the discretion to allow it to continue, even if that 24-month deadline is missed. And then finally, the WSIAT may also assign appeals to be heard in writing or by oral hearing. And again, parties can make a request for one or the other, but it is at the discretion of the WSIAT. And so that is everything for our brief 101 on working with the WSIB. And I will turn it back over to Matthew now.
Great. Thanks, Karina. A lot of information there. And so fortunately, we have about 10 minutes for questions to all of the panelists. And there's been some great questions that I see in the Q&A chat function at the bottom of your screen on the Zoom platform. So I'm going to start with the first question for Emily. And this is a question from an employer that has fewer than 25 employees in Ontario, but more than 25 employees in another Canadian province. Would they be subject to having the disconnect from work policy?
Thanks, Matthew. So no, they would not be. The policy only applies to workplaces with 25 or more employees in Ontario.
And what happens, Emily, if the employer has less than 25 employees in January of this year, but then they recruit a number of employees and have more than 25 by, let's say, September or October?
So the requirements of the policy are that if you end up hiring more employees over the year such that you exceed the 25 threshold, you don't need to implement a disconnecting from work policy. However, if you have more than 25 employees as of January 1st of the following year, so for example, January 1st, 2023, that is when you would have to implement a disconnecting from work policy.
Great. And then there's one question here as to whether the policy needs to be signed by employees.
So the ESA does not require that the policy be signed by employees, but you certainly can if you would like that acknowledgement from them.
Okay. And Emily, you said that there can be different policies in place at the same employer. We have a question about unionized employees versus non-unionized employees. With the unionized employees, they are required to sign daily cards that track their hours, whereas presumably the non-unionized employees are not. The question is, in that workplace, do they have to have the same policy apply to both groups of employees, or could they have different policies in place?
So it's really up to the employer in that case. If there are certain things that they would like to address as it pertains to unionized versus non-unionized employees, they can certainly go ahead and do that, but it's not a requirement that they have different policies. It's quite flexible, and it's really open to them to decide if there are different things that they'd like to cover in two different policies.
And then there's a question as to employees who are exempt from provisions of the Ontario Employment Standards Act, such as managerial employees or IT professionals. Are they exempt from the disconnect from work policy requirements?
So they are not exempt from those requirements. The disconnecting from work policy applies to all employees in the workplace.
Okay. And Karina, you have a few questions with respect to WSIB. The first question has to do with an employee who has been off work, probably on layoff since 2020, and presumably is on a WSIB leave of absence. Does the employer need to return the worker to work in 2022?
Thanks, Matt. So as I mentioned, the return to work or the reemployment obligations continue for either the earlier of 2 years from the date of the accident or a year from when the employee is able to return to their pre-injury duties. So if at this point the client or the employer has no information to say that the employer is able to return to work or the employee, then you're running on that 2-year clock.
And if in the end there's not enough business and the employer doesn't have any work to provide to the employee in 2022, would they still need to provide termination or severance pay?
Yes, so the WSIB obligations don't invalidate ESA obligations. So if ultimately the employer is in a position where they're comfortable that they can prove that there's no work to return the employee to, even if they're able to, then they do still have to comply with their ESA requirements to pay statutory notice and severance as applicable.
Okay, thanks, Karina. Emily, a few more questions for you here in the chat. The next question is, an employer has a hybrid work policy that talks about disconnecting, but the question is, does the policy need to explicitly state that it is the right to disconnect policy, or is it fine to have it labeled something differently as long as it covers the topic?
Thanks, Matt. And that's a good question. So one of the few explicit requirements of this policy is that employers must have a specific policy with respect to disconnecting from work. So although it's addressed in a different policy, there should be a separate disconnecting from work policy that employees can review.
So you could have an employee handbook and have the policy within the handbook, but it needs to be explicitly, the title needs to be there, disconnect from work policy. Is that right?
Yes, that's right.
Okay, and there's a subsequent question as to whether the policy could be called a guideline by the employer.
I believe the requirement is that it's a disconnecting from work policy. So calling it such, I think, is the best way to go.
Understood. There's a question as to an employer, if they have an employment agreement with a non-compete prior to October 25th, 2021, but then they enter into a new employment agreement with an employee after October 25th, 2021, whether that would potentially invalidate the non-compete if the employee is not in an exempt position. I think it would if the non-compete is restated in the new 2022 employment agreement. Although I think what one could do is keep the old version of the non-compete, and in the new employment agreement cross-reference the previous version of the non-compete, and in effect amend the employment agreement, but keep any terms, in particular the non-compete that existed before October 25th, 2021 in place, and to say that it's not been replaced by a newer employment agreement or a new employment agreement amendment. Okay, another question here is, will the reporting requirement, this pertains to WSIB, will the reporting requirement apply to employees temporarily working outside of Ontario or outside of Canada as part of a flexible location program?
So the answer to that depends on, one, what province they are in, as well as how long they have been outside of Ontario. So each province has their own workers' compensation legislation, and it speaks to whether it applies when you are out of province or not. So in Ontario, the WSIB continues to apply for 6 months. So if you're temporarily, moved out of province for a project, or like you said, for flexible work, for 6 months, it automatically applies. You can apply to the WSIB to request that it be extended beyond 6 months. But if we're talking about someone working outside of the country or for it being kind of on a more permanent extended basis, we would ultimately need to look at what are the workers' compensation obligations in that jurisdiction, which is why lots of questions and complications come up with these kind of extended remote work policies.
Okay. And this might be one of the first webinar series we've had since 2020 where we've not discussed COVID-19 in the workplace, but I'm going to continue to address it at least once with a question to you, Karina, as to whether an employer would need to report a case of COVID-19 to the WSIB.
Yes, so the WSIB has indicated that it considers COVID-19 to be an occupational illness. And so as a result of that, employers are required to report COVID-19 cases to the WSIB in the event that if you have an employee who reports to you, I have contracted COVID-19, if you have other employees in the workplace who have also tested positive for COVID-19, or there's reason to believe that there was a known or suspected contact in the workplace that could have caused that individual's positive result, that does need to be reported to the WSIB.
Understood. Okay, and one last question to you, Emily, and it's a question that seeks clarification as to the employer requiring to provide employees with a quote unquote a right to a disconnect from work policy, yet we stated in the presentation that there is no right to disconnect by an employee and that's non-enforceable. So just seeking a little bit of clarification on that distinction, which I appreciate is confusing given the language of the legislation.
Yeah, of course. So the policy in the legislation is referred to a disconnecting from work policy, so not a right to disconnect policy. And basically the requirement is that the policy needs to address what disconnecting from work can look like in the workplace. So there is no requirement that you give employees, the right not to answer emails or communicate at all. Really, the requirement of the legislation is it needs to be discussed and laid out how or rather what that looks like in your workplace. So it could say anything from you may be required to answer emails outside of standard working hours. It could say these are the expectations regarding emails and response times, et cetera. But ultimately, what the disconnecting from work policy does not do is give employees the explicit right to disconnect at any given time or for any amount of time.
Got it. Okay, thanks for that clarification, Emily. So with that, we're going to close. I'd like to thank our speakers and everyone who attended today's webinar. And again, be sure to subscribe to our Employment and Labor Law blog and the Canadian Employment and Labor Law podcast to get the latest in legal updates. Details can be found on our website and will be shared in the post-event email that you'll be receiving next week. One thing that we did mention today in Emily's presentation is this Ontario Disconnect from Work policy template. So the Denton's office here in Toronto and in Ottawa has developed a ready-to-use Disconnect from Work policy template that you can integrate with your employee policy handbook or provide updates to your own respective policy for your organization. And we're making that available to employers for a flat fee of 1,000 Canadian dollars plus HST. It also includes a FAQ, which is very helpful in understanding how the policy works. And that is an FAQ mainly for HR managers and the legal department, not for all employees. We also will provide any complementary updates to the template policy should the Government of Ontario publish any regulations prior to the implementation date, June 2nd, 2022, that could impact the policy. Although I think that with the current Ontario general election, any regulations being passed in this regard are fairly low. So you can request this template from any member of the Denton's Employment and Labor team. There's a link in the chat to order the template, and we'll also be sending a link after the webinar. So this is day 2 of 3 of the spring webinar series. Day 3 will be taking place again tomorrow at 12 noon Eastern time, and it will cover the latest on mandatory vaccination policies, a health and safety update, and what federally regulated employers need to know about the new federal workplace harassment laws. So please be sure to check it out. And last but not least, we're also hosting a 33rd session of our legal update for Canadian employers, another webinar on Friday, May 27th at noon Eastern time. So please keep your eyes out for that invitation. And with that, I'd like to thank you and wish you a very good day.